Hey everyone, even though we are spending two class periods on Lochner, and you would think that would be enough time to get through everything, I'm going to throw this up on YouTube/perusal just so that some of the background can be taken care of in advance. And I'm happy to answer questions about this material. You can either comment or annotate the video on perusal, or you can just ask me at the beginning of class. Either is fine. So, Lochner versus New York is one of the most important cases that we study for a bunch of reasons. One is uh, it marks a distinct era in American legal history. The meaning of the Constitution has really sort of ebbed and flowed over the course of American history, even though the text of the Constitution has stayed mostly the same. And so the it's hard to know what to expect from the court if you don't have a sense of when the case is being decided. So, whenever you're looking at a case in this class, there are two main things you have to figure out so that you will have a sense as to where the justices are coming from. The first is, what kind of case is it? Is this a case involving a federal law? Is this a case involving a state law? Because the powers assigned to each level of government in this country are different. And those differences matter. We've talked over and over again about Article 1, Section 8 of the Constitution enumerating federal power. And we've talked about the 10th Amendment saying that everything that doesn't belong to the federal government and is also not prohibited to the states belongs to the states. But the 10th Amendment sort of suggests that state government power is anything but federal power, and that's not necessarily true. The nature of state government power doesn't come from the U.S. Constitution. It comes in part from their state constitution, but the nature of state governmental power is called the police powers. Now, in a sense, there's one respect in which this distinction between federal government and state government doesn't matter, and that is neither level of government is allowed to infringe an individual right. There are some cases that we're going to study where the controversy is such and so that Congress did consistent with one of their enumerated powers. But there are other cases where there will be two questions: whether the law was within one of Congress's enumerated powers, and even if the answer is yes, is it infringing an individual right? Because if the answer to question number two is yes, the law still gets struck down. State government, even if it's a valid police power regulation, if it infringes an individual right, it's going to be struck down. I know I haven't defined the police powers yet, but I will on the next slide. So you don't need to. I mentioned at the beginning the importance of time and eras. Again, this isn't a history class, so you don't have to memorize the exact dates, but you should know the order and sort of roughly the, the if not specific dates, but the decades that it covered. The one specific date, by the way, actually, one date needs to be changed, and that is we are no longer in 2022. But the one specific date that is, I think, most important to keep in mind, because it's a sort of organizing principle in our class, is 1937. But I'm getting ahead of myself. We're in the early 1900s right now. So, what is this whole police powers thing? State governments have the authority to promote the health, safety, welfare, and morals of its people. Those are the police powers, making regulations to promote one of those four goals. So it has nothing to do with the power to establish a state police force or something like that. They mean police as in the ability to regulate people's behavior. I'm going to police how you go about studying for the exam. That's what they mean. Not that I was going to arrest you. So how do we know if a law is legitimately aimed at promoting public health, safety, welfare, or morality. And in in the civil rights course that's offered at UMBC, there's a lot more of a focus on, okay, well, how do we know that a government's claim that it's promoting public morality isn't just some sort of code for actually taking away people's rights? But yeah, we won't address that question in this course. So what does this mean? Well, in order to seem like it is a real and valid attempt to promote health, safety, welfare, and morality, those state laws must be reasonable. And of course, even if you have a legitimate law that seems reasonable, it seems very connected, the law seems like a decent way to promote some aspect of public safety. If that law infringed on federal power, the Supremacy Clause says that the state law must yield to the federal law, or a part of the federal Constitution. Okay, so here's the other um, uh, side of this case. Obviously New York is going to argue that the Bake Shop Act was designed to promote public health and safety, and Joseph Lochner's lawyers are going to argue liberty of contract. And this is a substantive due process right. We talked about this uh, last time. Substantive due process is a doctrine that developed when the 14th Amendment was added to the Constitution, and it said no state shall deny to any person life, liberty, or property without due process of law. Courts began to interpret the word liberty in such a way that it protects certain freedoms that aren't directly named in the Constitution. So if they're not named in the Constitution, how do we differentiate between, the right to marry, which seems like it would make sense being a constitutionally protected right, and on the other hand, the right to eat ice cream, which, though delicious, does not seem to be one of the most fundamental freedoms that we should prevent government from regulating any aspect of our ice cream life, right? So the the uh, the way that the courts sort of describe substantive due process is the term liberty would be meaningless. It would lose its substance if we, allow the government to do X, Y, or Z. That's sort of the way that the courts try to identify whether a given freedom deserves protection under substantive due process. Liberty of contract was a substantive due process right, and then the court changed its mind in 1937. So we're about to see the rise of it and then spend about a week or two talking about the rise of liberty of contract before we talk about how it was interpreted away. So liberty of contract presumes that adults are capable of making their own business arrangements without arbitrary government interference. Because the thought was, if the government takes sides in an economic dispute between one industry and a completely different industry that are vying for consumer business, if the government stepped in and favored one business at the expense of another, that the government decided to back Facebook, and so passed laws to attack Twitter just because they were trying to do Facebook a favor, right? So there's this idea that if the government gets involved and the law ends up sort of advantaging one side and disadvantaging the other, that's unfair, might even be corrupt. So the better thing for government to do is to stay neutral, and that seems like a pretty bold libertarian thing to say, that just let the free market always take care of itself. And it sounds, very libertarian today when we've got, lots and lots and lots of billionaires. But the perhaps the thinking at the time this idea of liberty of contract was developed might actually sort of make us rethink it. The idea of government staying neutral um, kind of might have made sense early in American history, where if you set aside the slave economy, and I know that's a big sort of asterisk to make, but there were because industry hadn't really been developed, most businesses were fairly small. And so with small businesses, there isn't a huge difference in power between owners and workers because you know, owners don't have a ton of money to replace their workers on a regular basis. Um, and the other assumption that was made around the time of the American founding, which is when liberty of contract first gets sort of developed in its very sort of abstract form, is that if if you found economic unfairness, or sorry, if you found that the market wasn't working out to your advantage, uh, there was always land further west and cheap land. So if Philly was screwing you over, don't stay in Philadelphia. Go west and set up shop somewhere else. Do what Peter Mugler did. Kansas gets rid of alcohol. California's not going to, so he moves out there. And the ability to sort of relocate seems like a very privileged thing to do now. That if you're lucky enough to have the money to do that, good for you. But most people can't. The assumption was back then that most people could try to relocate if they wanted. So again, the government should stay neutral and not play favorites. Let the market take care of itself. But of course, if the market is uninterfered with, bad things could happen. But if bad things happen, they'll all right themselves in the long run if people move further west, where there isn't, some sort of um, where there are more opportunities and fewer risks. But of course, this case is being heard in 1905, not 1805. We are at the height of the Industrial Revolution. Um, and so, we might take a different view of what it means for the government to get involved in a business dispute instead of taking evenly matched scales and tipping them so that one person wins and one person loses. What government intervention might actually be doing is seeing that the scales are already out of balance, that ownership has way more economic power than workers. Government intervention resetting the scales to be even with each other, that isn't really playing favorites. That's just restoring the conditions that were supposed to be there to begin with. Um, so I know this is a doozy of an idea, in no small part because um, even though liberty of contract is no longer viewed as a substantive due process right, it kind of sort of there's some similarities between liberty of contract and substantive due process rights that currently, well, kind of sort of exist. It depends on what the Supreme Court has done since I've recorded this video. But the notion of the right to privacy is based on the notion that grown adults can make their own decisions without arbitrary government interference. You take out the words economic decisions and you put in relationship decisions. Um, and that's how you get privacy instead of liberty of contract. Um, Liberty of contract is an old idea that gets tested in a new time. It's one way of thinking about it is that it promotes economic equality. Another way of thinking of it is that neutral government staying neutral actually exacerbates economic inequality. And yet there's this weird sort of commonality between the assumptions that support liberty of contract and the current sort of substantive due process rights that we talk about today. So if you have questions about liberty of contract, that's totally fine. There's a reason why we're studying this for multiple classes just for Lochner, and then we're studying a bunch of other liberty of contract cases over the next few weeks. Okay, but so all this, I covered all this ground before even sort of throwing out there, make sure to organize your reading. Um, so, what are the facts? I've labeled them facts 1.0 because I've got a little something up my sleeve for when we're finishing up the lecture before we head into discussion of the case, where I'll be revealing more facts. But the initial facts are that in 1895, the state of New York passed the Bake Shop Act. And one of the most important provisions said that bakery workers couldn't work more than 10 hours a day or 60 hours a week. Now, that's not the only thing the law did. It also regulated sanitation standards in bakeries. And that was a huge issue. We'll talk more about how unsafe it was, unhealthy it was to work in a bakery um, in class. But, as you will know by reading through the case, the complaint here was only about the work hours provision. So the sanitation standards, since they weren't an issue in the case, the result of this case did not strike down that part of the law. So that's New York, who's Joseph Lochner. He's a German immigrant. He ran a small bakery in Utica, New York. And he actually volunteered for, so I should introduce the term test case. When laws are passed, you have to find a way to break the law before you can go to court and argue the law is unconstitutional. So you can't just, as soon as the law gets signed by the president or the governor or whomever, you can't just go to court and say that, you want the law to be struck down. Remember, courts exist to right someone's wrong. And if you just don't like the law, you haven't been wronged. So you have to find someone who will actually, violate the law and risk whatever punishment the law imposes in order to have a chance to challenge the constitutionality of that law. So Joseph Lochner worked together with his employee, Armand Schmitter, and they were like, okay, I'm going to ask Schmitter to work more than 60 hours in a week, and then Schmitter's going to go to the cops, and I'm going to get arrested for violating the most important part of the Bake Shop Act. So here is Lochner's bakery in the sort of like main it was the center of town in Utica. As far as I can tell, the Lochners sort of remained in that area of New York all the way through like the 1970s. And here's a little excerpt of the Bake Shop Act. No employee shall be required, permitted, or suffered to work in a biscuit, bread, or cake bakery or confection establishment more than 60 hours in any one week, or more than 10 hours in any one day.